Yea, 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 all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and upon the Commonwealth. Draw near, your attendance, they shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Welcome to the Appeals Court. I am William Meade. To my right is Justice Massing, and to my left is Justice Sachs. Will be the panel for all of the cases this morning. I know you are both very familiar with how things are done here, and the other attorneys as well. Each side gets 15 minutes. You needn't use all of your time. My best advice is get right to the point. We do not entertain rebuttal. With that, I'll call the first case, which is 22P 1177, Commonwealth versus Berry. Mr. Nam Crane.
Good morning, Your Honors. Mr. Nam Crane for Mr. Berry. May it please the Court. I'd like to start quickly with the evidence about nighttime. And the Commonwealth, as you know from reading the pleadings, the Commonwealth needed to prove that Mr. Berry had arrived there before 5 a.m. The jury wasn't told when sunrise and sunset were, but that was what they needed to prove. And the evidence on that is completely speculative. He arrived at her house at 2:15, but then that's all we know. We don't know when he arrived. There's no evidence of light. There's no other evidence to triangulate when exactly Mr. Berry was there. This is very much unlike the cases cited by both parties in which there was some evidence of the behavior of the assailant, where he was when, where he may have been, what the light was like, other evidence to triangulate presence at the relevant time. So I think in that regard, the Commonwealth failed to prove that element.
I suppose we can't rely on your client's testimony as for proving that, but his testimony would suggest that he got there in the nighttime, right?
I'm sorry.
His own testimony suggested that he got there in the nighttime.
Well, yeah. There's evidence after the Commonwealth's case in chief, but again, that's not what I'm talking about.
So it would be B&E in the daytime then?
There was no instruction as to there's no lesser included instruction that those offenses simply fail, and they would have to be entered as not guilty.
But if it wasn't, I think we all agree that it's duplicative, right? So. Well,
there's another reason why those would both be vacated and dismissed as duplicative, but they're also not. But as having failed to prove them altogether, they wouldn't be even aggravating factors to the aggravated rape charge.
Well, the B&E nighttime was placed on file, right?
Not legally, no. It was not at the.
Was it objected to?
Well, no, but the proper proceeding.
So that's not even before us.
Well, I would, in my brief, argue why that would not be, that should also still be vacated and dismissed. But also, given the fact.
The Commonwealth agrees that it's duplicative. But
yes, Your Honor.
Let me ask you something different.
Sure.
Under 265-22A, which enumerates the qualifying aggravating crimes, breaking and entering daytime is among them.
That may be, Your Honor, yes.
Yes. So if the evidence was insufficient to show nighttime but did show daytime, and all other circumstances considered, we would send it back for resentencing on B&E daytime, right?
I don't agree, Your Honor. I think it would be, because again, that was not the Commonwealth's.
Just go with my hypothetical.
I'm going with, if Your Honor was correct, then legally, I would, yes, obviously. But that, I don't believe that would be the correct proceeding. I think you would have to dismiss those charges outright as having not been proved.
Even though the Commonwealth had sufficient evidence of B&E daytime, the defendant gets a windfall because they didn't prove a greater offense.
I don't characterize it as a windfall. I characterize it as legal process. I characterize it as the Commonwealth presented its case, did not ask for lesser included instructions. They failed to make their case, not guilty.
Can I ask a question about the ineffective assistance?
Yes, please.
You offer an alternative theory. How does that theory, or that should have been presented, how does that account for the victim's testimony that she'd never met the defendant before this incident, and the fact, the victim's testimony and her friend's testimony that the defendant said, "See you later," which was not her name. I'm sorry, I shouldn't use the name of the roommate, friend, but was not the name of the victim, and therefore suggest that he'd never met the victim before.
Well, you have two questions there, Your Honor. Let me address the first one. What you're referring to as far as how, when she, the fact that she didn't remember him, that would go to the physician's statements about state-dependent memory, and which is again, that's not common. When I read about state-dependent memory, I was really surprised. I mean, I'm a 55-year-old American, and I have familiarity with alcohol as we commonly do, but that was surprising to me, that you can remember things, you can learn things when you're drunk, then forget them when you're sober, and then remember them when you're drunk. That's state-dependent memory.
So the idea is that she introduced herself to him on some prior occasion when she was intoxicated.
Right.
She forgot that when she was sober and talking about the incident, but then she remembered it again when she was intoxicated on the night in question?
Yeah, and that's how state-dependent memory works.
But how does that account for, okay, so that's the first one.
Yes. So the second one, well, that's, they testified that he had said that to her, that, this is, it may be that, that's what she believes she heard, that, he could have confused her with her roommates. I don't know. I can't answer why they said that.
She testified to it and the friend on the couch.
Right. I don't know. I mean, that, again, Mr. Barry and Alice had not met each other like one previous occasion. They may, he didn't know her well. He may have known her roommate's name and confused them. I can only speculate about the nature of how that falls in. That would be a question, again, it's a fair question, but it would be, again, how we weigh that, how we look at that would be a question for the jury.
So she would have to have been, under your theory, that she was so intoxicated that she forgot she consented, but at the same time not so intoxicated to have been incapable of consenting.
Well, under the, I think it's the Block case, I'm not sure how to pronounce it, the defense would be whether Mr. Berry had perceived that she was able to consent. And as the physician affirmed in this case, people who are intoxicated or in a blackout state may appear to be perfectly lucid. People try cases, fly airplanes while they're drunk and they're in blackouts, and everyone else around them thinks they're fine, but they're not.
A problem I have with that is that unlike a case where defense counsel fails to call an expert to evaluate the defendant and can talk about him and his mental state or condition under various circumstances, these experts could only offer generalized testimony about what these things are and could not at all depict anything as it related to the victim. It was guesswork.
Well, I think, you're right, Your Honor. They would not have, at least under these facts, they had not an opportunity to examine Alice. But they did look at the record, and they looked at the fact that she had, drank a lot that evening. And so they could talk about people who have drank that much and in what their knowledge is about.
Can I just interrupt? There's so many variables that go into how much consumed alcohol, not the least of which is body weight and tolerance.
That's true. That's true, Your Honor.
We didn't know any of that here.
Well, she was on the stand, and the jury was perfectly able to look at her and judge her height and weight as much as they could. There may have been in her medical records.
Could you tell whether I or Masking could drink more based on looking at us?
I would not hazard to guess, Your Honor.
No, and neither could the jury.
Right. But we do know from the facts that she's a grad student. She's a young woman. She goes out at night. She drank as much as she drank, and her friend talks about her state as being inebriated or not, and all that kind of thing. And you're right. Nobody can can look back and see exactly how she was at that point in time, in that point in history. But what's important about the expert testimony is that they can educate the jury about things like state-dependent memory, about things like blackouts and how people can seem lucid in blackouts, and Dr. Strain's evidence about, you know, the dynamics of memory and how it's really reconstructed, and it's sort of counterintuitive how memory works. And from that, the attorney would then have the information he needed to make the arguments he needed to make.
But you'll agree that just having an alternative theory of defense to the one that didn't work is not ineffective assistance.
No,
you need to show that Attorney Levine's choice was manifestly unreasonable. And he himself says in an affidavit that he's familiar with this science, he's familiar with this sort of expertise, and he has used them in the past. And it was his belief that it was too risky to put them on the stand and subject them to cross-examine, maybe ask some of the same questions I just asked you, which in his opinion would be too risky. Why is that manifestly unreasonable?
Well, I think it was important to look not so much. Well, first of all, let me just refer the court to some of the cases that have been cited that sort of reach on this issue.
I'd rather you answer my question.
Well, I apologize, Your Honor. Why is it manifestly unreasonable? Because under the Sixth Amendment, you know, the two principles. Under Strickland talks about, and I think the Commonwealth may hit upon this, that every effort must be made to eliminate the distorting effect of hindsight and to evaluate the conduct of counsel from perspective at the time. So I think that's what you're sort of hinting at. But also under the Sixth Amendment, and by necessity under Article 12, counsel's perspective at the time must have been guided by the obligation to conduct a thorough investigation. And that's stated explicitly in the Wiggins case, 539 U.S. 510. Now, you can't have a strategy if you don't do thorough investigation. You can't say
So it was unreasonable for him not to investigate expertise in science of which he was already aware.
He is a lawyer, he's not a physician. I've done lots of DNA cases, right? For instance, I would not go out and pursue a DNA case unless I also consulted with an expert. As much as I think I might know about some subject, I'm not an expert in any subject other than maybe the law, suppose on a good day. So for him to think that he knew enough about issues that touched upon things like state-dependent memory, which I never heard about, is hubris on his part.
Well, I mean, that's conjecture.
No, I think it is, because and again, the Sixth Amendment dictates thorough investigation, not go about what you know, like not go about not thinking I know everything that's needed about this subject. That's hubris, Your Honor. And the Commonwealth
not go out and pursue a defense without talking to an expert, but might you decide not to investigate a defense further because you've seen this issue before and you don't think it'll fit this case?
Again, I don't think that meets the definition of thorough investigation, but particularly when you have a subject that's not legal but factual and sort of and scientific, like the effects of substances on the brain. So, and I think that one of the things this case is lacking is an evidentiary hearing, because we don't know exactly what trial counsel knew about these subjects. He claims he knows about these subjects, and he's used experts on this before. But what exactly that was? Did he know about state-dependent memory? Did he know about reconstructed memory? Did he know about how much did he know about blackouts and things like that? We have no idea because there was no evidentiary hearing. So if you want to answer questions like that about what this person knew, like what the trial counsel knew, and whether his decision really was reasonable, I would say that we need to have an evidentiary hearing. Seeing no more arguments on that issue, I'll just quickly touch upon the improper argument issue. And I think that clearly, and Justice Gaziano picked this up, under person. Obviously, when you start commenting upon the defendant's ability to watch the trial, you're touching upon rights under this, confrontation and presence and things like that. Now, Justice Gaziano tried to cure that with a fairly good instruction, but the problem is after that instruction, the jury is generally instructed that to use your observations of the witnesses, ask yourself what was the opportunity or lack of opportunity that the witnesses had to see and learn the facts to which he or she was testifying. So Mr. Berry was a witness. What was his opportunity to learn facts? There's no qualification of that instruction. You could
the problem, you're understating the problem in person versus what occurred here, though. In person, there was no specific instruction like then Judge Gaziano gave. And in person, and that was after the tailoring type argument, in person the defendant did not make any statements to the police, whereas this one did. He lied to the police. And in person, the prosecutor argued that after the shooting, the defendant promptly contacted an attorney inferring consciousness of guilt, which was, of course, improper. None of those things happened here.
No, Your Honor. There are distinguishing elements of the case, and you're right. In person, there wasn't this curative instruction. But I think that what I think is important is when the jury heard Berry, right, and they heard, and in effect, that he testified on his own, and that his testimony was really, his testimony versus hers. And then the Commonwealth says to him, well, you know why he said those things, right? Because he watched the trial. That could not, I would argue that can't be unheard.
Okay, thank you.
Thank you very much.
Mr. Lynn.
Pardon me. Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. There's one thing I realized as I was preparing for this argument, and that is there is no evidence whatsoever in this case that the victim was more intoxicated than she appeared to be to the lay witnesses. The only evidence of how intoxicated she was the testimony about how much she had to drink, how she appeared to the people she interacted with, and her claim that she didn't remember anything in the morning. That's the only evidence in this case of how intoxicated she is. There's no suggestion here that she seemed to be okay, but she was really, in fact, very, very intoxicated. So if defense counsel had called an expert to testify that you might seem to be okay, but you're actually really, really intoxicated, far too intoxicated to provide consent, meaningful consent, that would have undermined his defense, that she, in fact, was not that intoxicated, that she was able to use the little card reader in the back of the taxi, that she was able to speak to her roommates, that although Caitlin, the friend, testified that she seemed to be debilitated, that she was still able to do these things. She was still coherent, and that was the gist of his defense. And to have called an expert to testify that she could have been incapable of giving meaningful consent, even though she appeared to be capable of it, would actually have undermined that defense. So it was far from manifest.
Well, I mean, wouldn't, from the defendant's perspective, wouldn't it stop that she appeared able to give consent?
I'm sorry, I didn't hear that.
From the defendant's perspective, wouldn't it stop that she appeared able to give consent?
Wouldn't it what if we
stop there? I mean, hey, she appeared able. I thought she consented. She appeared able to consent. I couldn't tell that she was drunk.
Correct.
So I don't quite follow your point there.
Wait, the testimony is that the testimony is all lay testimony here about how she appeared to be. Caitlin testifies, opines that she's
right. And the defendant testifies too, right?
Right, and the defendant testifies and said she seemed to be fine. She seemed to be tipsy like she was the last time. So that's the evidence. She either is or isn't too incapacitated to give meaningful consent. At that point, there's no expert testimony. There's no suggestion that she might be more intoxicated than that she appears to be. It's just a question of how intoxicated is she, a pure question of observation and credibility.
So how do you respond to Attorney Noam Crane's argument that it's a failure to make an informed decision is what he's talking about?
Well, again, as the Court has pointed out, This isn't the typical situation in which you call an expert to evaluate your client and find out that he has serious cognitive disabilities that would prevent him from being able to form deliberate premeditation or the like. This is a situation in which the expert is only going to be able to provide general testimony about the nature of intoxication and memory. And that's something that an attorney can know about based on prior experience. I think, as I argue in my brief, the defendant greatly overestimates what the expert witnesses would have been able to testify, because they never examined the victim. They know nothing about the victim. Again, as I point out in my brief, the only evidence that she's ever been intoxicated before is the defendant's testimony. And one of the witnesses opines, well, she's an occasional heavy drinker. There's no evidence of that in this case. There's evidence that she got drunk. That's the only evidence in this case. So they would have just been able to say, you can look more capable than you really are. You can be more intoxicated than you appear to be, and that's pretty much common knowledge. So it certainly was not manifestly unreasonable, nor a dereliction of duty for defense counsel to make this decision based on what he knew. Are there any further questions on that issue? Turning to the nighttime issue, I would first agree with Justice Meade that the absence of a lesser-included offense instruction in this case does not prohibit this court from finding a lesser-included offense. The purpose of a lesser-included offense instruction is to give the jury the option of not having to make an all-or-nothing decision. But where the jury does, in fact, make the all decision, which is what they did here, they found all the elements of the crime. This court can always say, if there is one element that was not met, that the defendant was nonetheless guilty of a lesser-included offense. But I don't think this court needs to reach that issue based on Kingsbury and Boyd, which I cite in my brief. In Kingsbury, it's evening. There's evidence that this could have happened, this crime, this break-in could have happened as early as 6 or 6:15, depending on how you look at the evidence, and as late as 7:10. And the court explicitly says where you have that kind of a range, the evidence in the light most favorable to the Commonwealth is that it occurred at 7:10. Granted, there is some evidence that it was dark. There's direct evidence that it was dark. But at that time of night, it could easily be darkish, but still not an hour after sunset. Same thing with Boyd. You've got no evidence whatsoever of what time the second break-in occurred, or possibly the first break-in. We don't know the order. In fact, probably the first break-in, because they arrested him not long after the woman caught the defendants in her house. All we know about the other break-in is the defendants are on the same road as the house. The house is nearby the house where the woman caught them, and that the owner of the house was out from early morning to late evening. And the court says we can still infer from those circumstances that the break-in occurred during the nighttime. So based on those two cases, the evidence in the light most favorable to the Commonwealth is he breaks in at 2:16. That's 2:15 is when Caitlin, the friend, falls asleep. He could have come in a minute.
Is there evidence that he broke in at 2:16? Or is it just saying, we know he broke in a certain window, so we're going to assume in the Commonwealth's favor that it's at the earliest possible time?
We're going to draw the inference in the light most favorable to the Commonwealth, as opposed to a...
The inference from what?
From excuse me, I'm having a bad cough today. We are inferring from the fact that it could have happened as early. We are taking the fact that it could have happened as early as 2:15 and inferring based on the evidence in the light most favorable to the Commonwealth, or drawing the inference that is most favorable to the Commonwealth, that he therefore could have broken in any time after that. And there was a good, see, my math is terrible, 2 3/4 hours before, an hour before sunrise, 3 1/4 hours before sunrise.
Separate question about this issue. The aggravated breaking and entering was, even if it can't be separately punished, why can't it be used as the aggravating factor for the rape? So aggravated breaking and entering was the lesser include of...
Correct.
aggravated burglary.
Correct, yes.
So
Just-
could the breaking and entering be the factor that aggravates the rape, and then the aggravated burglary be a separate offense that could be punished?
I could not find any authority for that. I, of course, welcome the court to make that decision. I looked and I could not find a direct authority for that proposition. If I missed it, please feel free to do that.
Is that inconsistent with the theory under which the lesser included offense, if it's the aggravating factor, cannot be separately punished?
I'm not sure what the question is.
Is that inconsistent with the theory of the cases that you cite for and base your concession on? That where the aggravating factor is the lesser included offense, then one can't be punished for both the lesser included offense and the aggravated rape.
If I understand your question correctly, yes, of course. There's the case law is clear that where there's only one aggravating offense, you can't be convicted for both you can't be convicted for both the greater offense and the lesser offense. The sentence for the lesser offense or the conviction for the lesser offense has to go. Here we have a very interesting situation because we have three tiers. We've got the greatest offense, which is aggravated rape. Then we have the lesser included offense of that, which is burglary. And then we have burglary with assault. And then we have the lesser included offense of that, which is breaking and entering in the nighttime. Whether that makes it two, again, I could not find any authority that makes it two separate charges. And if it were, it would be, I think the burglary would be the one that you could save the burglary as easily as you save the breaking and entering in the nighttime. But I just could not find a case that said that explicitly. If this court has any questions about the prosecutor's cross-examination and I will field them. I want to make one thing clear. It's in Mendez, which I cite in my brief, the court makes it clear that where the defendant has made a prior statement to the police and then gives testimony at trial that is inconsistent with that statement and consistent with the evidence at trial, it is not error for an imposition on the defendant's right to be present at trial for the prosecutor to say, look, he made a statement before, now he's making a new statement that's totally different from that and consistent with the evidence.
But, and so that's fine when the prosecutor argues, well, previously he told the police, I wasn't there, right, because now we know he was there. But the prosecutor also said, well, he can't say I met her earlier at the bar because we know that's not true. He can't say I came home with her because we know that's not true. He never said those things to the police or at any time prior to trial.
Correct.
So how can, so that's a direct accusation of tailoring. That's not merely pointing out to the jury that he changed his story.
I would disagree. It's still saying that he changed the story because his story is before. He's never there. And now, also I'd point out that's I see what you're saying. I understand the point. But I think the bottom line is he's pointing out that his statement differs from his statement to the police. His testimony now differs. And even if there is an error here, it is completely cured by the judge's immediate and forceful and direct curative instruction that you are not to consider the defendant's ability to hear what the other witnesses said. So even if there is error, but I still would argue that this is in a situation where a defendant gives a prior statement and then gives inconsistent testimony at trial. It is not error to point that out in any way. The other item I want to make, just want to draw the court's attention to briefly is the prosecutor's argument regarding cross-examination. This isn't a case in which the prosecutor is saying, how dare defense counsel challenge this witness? What he's saying is, defense counsel is challenging this witness because she did innocent things. He's scrutinizing her because she made coffee. He's scrutinizing her because she took a shower. That's proper argument to say these aren't reasons why you should disbelieve the witness, even though defense counsel is asking you to.
You have to mention defense counsel by name in that kind of argument?
No, you don't, but I think, yes, it was. Never mind. He did mention it by name.
And that doesn't seem like disparaging the role of defense counsel, criticizing him and ridiculing him for doing his job, which is to try to test the witness's credibility?
No. The prosecutor is entitled to argue forcefully. He's not saying this man is a monster because he's cross-examining the witness on these ways. He's saying this man is wrong because these aren't things that make this witness less credible. That's what the argument is. And if there are no further questions, the Commonwealth will otherwise rest on its brief.
Thank you.
Thank you.
Thank you both. Our next case is 23P Commonwealth versus SOUVANNASAP. 50% chance I got that one. Ms. Contartesi.
Please the court, Adriana Contartesi for the defendant appellant, Mr. SOUVANNASAP. In this case, Mr. SOUVANNASAP contends that the evidence was insufficient to convict him of assault and battery, dangerous weapon, to wit, a blunt instrument, where there was never any evidence of what the blunt instrument could have been, to the degree that, and combined with the jury instruction, that the jury really would have had to have employed conjecture to find that it was a blunt instrument rather than a fist or a knee, that it was an instrumentality.
Well, doesn't she testify that he's throwing things at her?
She did testify that
So is that enough to and the one hit her in the forehead?
She never excluded being hit by something that wasn't an object.
Well, but you said they would have to speculate, but she actually said he threw hard objects at me and he hit me. He threw a hard object at me, hit me in the head.
But what could that object have been, and how much different would the conviction on this case, and I don't have much, but I think that this is a really good issue, how much different would that conviction have been had the judge given an instruction that said, you first have to find that this was an object rather than a bodily part, rather than a fist or a knee.
Where does that come from? I mean, he throws an object, according to her, throws an object at her, hits her in the forehead with sufficient blunt force, as the SANE nurse testified, to cause this welt to come up on her head. And why can't we say that object, whether it was a rock or a bowling ball, was dangerous as used based on her injury?
Because we don't know what the object was. There was never any evidence. If you even look at the exhibits, what in the tent could have fulfilled that?
Her cell phone.
Pardon me?
Couldn't it have been her cell phone?
The cell phone, in order for the jury to have found that it was the cell phone, the jury would have had to have employed conjecture to get to that point. I could see them in the deliberation room. Well, what about the cell phone? Yeah, okay. That is not a sufficiency of evidence, and it demonstrates that the evidence was not sufficient to give that issue to the jury even. This is a de novo review, and I'm certain that the panel would have expected that throughout this entire jury trial that there would have been some element. And remember, even the cases that my sister cites, the cases that I cite that talk about, well, the object, it's not an essential element of the crime. Yes, it's not. But the particular object is not an essential element of the
Speaking
crime.
of the cases that Ms. Johnson cited, what about Commonwealth versus Liakos, where the use of a dangerous weapon, where they don't find the weapon, no one testifies to what it was or is found, is nonetheless it's dangerous as used is inferable from the victim's injuries.
I might have gotten all my cases that
It's a chestnut from like 1981, the first year Justice Smith was on this court.
Is that the
It's the razor blade one. It's the one with the razor. It's like the razor blade one.
I'm sorry, pardon
It's
me?
the razor blade one.
Well, there you go. I mean, the injuries were such that it was very easy for the jury to infer. It was reasonable and easy for the jury to infer that it was a knife or a razor blade. Same with
the sane nurse testifies that the object use was blunt force trauma, inconsistent with pressure. Why isn't that sufficient?
She said that she said that it was a blunt force trauma that did not break the skin, that it was consistent with a baseball bat or a bottle, but she never said that it was inconsistent with a fist or a knee.
Well, she did say it was inconsistent with pressure.
But how is that? So what is the jury supposed to do with that? A baseball bat or a bottle doesn't apply pressure? And then we have this field, we have this tent full of stuff, we have this field, pictures of this field. Nothing is pointed out except as Your Honor pointed out, the cell phone. But still the jury would have had to have employed conjecture. And I'm not asking the court to throw out the entire conviction, but just to find that in order to
Was anyone else besides the defendant throwing things at her?
No, not
So
according.
why would we have to employ conjecture that one of the objects thrown by the defendant was with sufficient force and with sufficient density to cause that wound, making it dangerous?
Because we cannot even come up with what that object might have been without employing conjecture.
But you've already admitted that it's not an element of the crime.
It's not an element of the crime. The cases that cite that talk about particular instances. For example, one case that cites that in the briefs is, the particular objective instrumentality is not an essential element of murder. Well, of course not. And then other cases that talk about that particular instrument is not an essential element of the crime. Stress the word particular, but also, too, in every single case, there's evidence of what it could have been. For example, I think in Rumpkin, there was evidence that the defendant was hiding something up his sleeve, could have been a pipe. The indictment was changed to just a blunt object, and the defendant had an injury that was consistent with a pipe. It was round and matched a pipe. In other cases, we have razor blades. We have, does it matter whether it was a shod foot or a booted foot? So there always was something for the jury to take back to the deliberation room to decide, was this a dangerous object in and of itself, or do we need to make that determination that it was used as a dangerous object? In this case, the jury did not have enough to do those things in the deliberation room without using conjecture, which is why this should not have gone to the jury, in that the 25B2 motion should have been allowed prior to it having gone to the jury on that issue.
Can I ask you, you have a pending motion for us to order the clerk to transmit some exhibits. What will the exhibits help us? How will the exhibits help us?
Well, because this is this crime scene, and it demonstrates that there's a whole bunch of stuff in the tent at the scene of the crime, and we know that the scene of the crime was inside the tent, not outside of the tent. The police went and they took pictures inside the tent, and the police went and took pictures inside the tent, and the police went and took pictures outside of the tent, and we just see fields of things, but nothing that the jury could look at and say, that okay, so that could have been it. But really, unless it was something that really matched that injury, how could the jury have made that conclusion without employing some conjecture? They needed a little bit more evidence, maybe not much, but they needed something.
So, I mean, usually parties put things that are on the record in their appendix. Like, I've seen many appendixes with pictures in them. Do you have the pictures? Could you just send us the pictures?
I do, and I think I tried. I think I tried a couple of times to submit them. But I think it just kept getting rejected by the e-filing system. Okay. So I thought I had cleared it with the clerk in Middlesex to send them over, but I had scanned everything, so I have the scans.
You can do it the old-fashioned way.
I can do it the old-fashioned way. I know, paper and everything. Sure, I can bring some copies in.
I think that would work.
Okay, but it would have been nicer if the panel could have seen the color copies, which is
well, maybe
what
you could work with the prosecutor
the black and white
to get us good copies of.
Oh, I know that she would cooperate. I'm sure she's been very nice. I don't have anything else, but I do believe that as to this particular issue, the defendant did not receive a fair trial on this, that the jury instruction definitely prejudiced him. It allowed the Commonwealth to skip over a step of evidence that it really needed to prove its case. And I will get those. I will work with ADA Johnston, and we will get those over to the court, and I know the court will agree on this issue. Thank you.
Ms. Johnson.
Thank you, Your Honors. May it please the Court, Melissa Johnson, Assistant District Attorney for Middlesex County, here on behalf of the Commonwealth. I will just start out by saying assault and battery with a dangerous weapon does not require that the Commonwealth prove the precise identification of the object that is used as a dangerous weapon. That can be inferred by the wounds to the victim, and we know that from Liakos, as Your Honor pointed out, as well as Smith. And in Liakos specifically, the doctor testified that the wounds that the victim suffered were caused by a sharp instrument. That's really all that we knew for sure. He had numerous stitches, but there's really no weapon seen. Now here we have, and it's, again in the light most favorable to the Commonwealth, the victim had testified that the defendant was throwing stuff at her. And one of those objects that he threw at her was especially heavy, and it fell on her forehead, which caused, as numerous witnesses testified, a huge lump on her forehead that literally was growing by the second after this assault. And so just based on the victim's testimony alone, that satisfies everything that the Commonwealth needs to prove in terms of assault and battery by means of a dangerous weapon. That's the dangerous weapon there. There was some sort of object that he threw at her forehead, according to her testimony in the light most favorable to the Commonwealth, that caused that injury.
In both Smith and Liakos, the wound pretty much reflected an object, whether it was it was knife wounds or razor blade wounds or a round circular mark in Smith. And here there's nothing like that that would be consistent with that. Would make it not consistent with, say, a knee. Is there?
Respectfully, Your Honor, I do disagree with it. It really was like a knot on her forehead that was bulging. And the EMT, I don't believe it was actually the SHAYNA nurse. It was the EMT that had testified in his or her training experience. This appeared to have resulted from a strike by a blunt object like a baseball bat or a bottle. So the injury was definitive enough where the EMT, in their experience, could testify as to the type of instrument. Just like a razor blade in Liakos, they could testify to the type of instrument that had caused that particular injury. Does that answer your question, Your Honor? And then in terms of the jury instructions, I will point out, number one, they were not objected to, so we're talking about substantial risk. And here, the instructions began, like any ABDW instruction, that the Commonwealth must prove that the assault was done with a dangerous weapon, and then the judge went on to describe the type of object, meaning separate object, that could incur such a assault. So the jury, and we have again to look at this in the substantial risk of the miscarriage of justice, the victim's testimony, there was no alternative testimony that was caused by some sort of part of the defendant's body. She testified definitively it was caused by stuff he was throwing at her. That, in terms of the instruction, left really no doubt in the juror's mind that we're talking about a separate object that the Commonwealth needed to prove. If there are no further questions.
Seeing none, thank you.
Thank
Thank
you.
you both. Our next case is 22P 1172, Commonwealth versus BRETAL.
You have an easier time with the other one.
What's that?
You have an easier time with the other one.
Yeah, I know, huh? I know if it's long or short. Mr. Batten.
Judge, may I proceed?
You may.
Good morning. Greg Batten for SHAYNA, BRETAL. I'll be brief, Judge. I did file a Rule 16L letter with the court citing to the Commonwealth versus Mahoney case.
I was wondering, how does that help? What are we supposed to look at in Mahoney?
Well, Judge, facts of the case came in. The defendant was charged with larceny, over $1,200. And what the government essentially proved and what the judge bought, the facts actually bore out, established an embezzlement and not a larceny. So on November 17th, CUNA goes in with his $1,500 in cash, all $100 bills, goes in to pay. Two people are behind the desk. The court clearly inferred from the evidence that it was Ms. BRETAL at that particular point in time because she was working that day along with somebody else. The evidence, I guess the judge inferred that she received the money. So she's employed by the dental office. She greets people. She accepts cash payments, reports the cash payments as part of the protocol, if you will. CUNA pays, and then he leaves.
Does she report the cash payment?
Well, that's the evidence.
You're talking about Mahoney, or you're talking about this case?
I'm talking about this case. The money was received by somebody. There's no dispute. That's how the evidence came in. So if you're going to point the finger at BRETAL, then obviously she's in rightful possession of the money when she gets it, and then it's a conversion problem. So it's not a larceny by taking. It's not a trespassatory taking. It's not a stealing. So the motion for required finding of not guilty as it's charged larceny should have been allowed because elements of larceny can't prove an embezzlement and vice versa, despite the merger under 266 Section 30. So on that note, I don't think the charge can be sustained. If the court's inclined,
if the money was given to her and she kept it or took it with the intention to permanently deprive, why isn't that a larceny?
Because she's rightfully in possession of the money at the time she received it because she's working for the company and taking the money from a potential client or a patient. She didn't take it. There's no trespassatory taking. There's no stealing. He comes in, here's the money. She takes it. She's lawfully entitled to possess it at that point in time. Embezzlement is now the conversion. It's what she does after with the money. She converts it to her own use. So you can't hook her for larceny on these facts because it's not like she walked in.
So we can send it back for an embezzlement trial?
You can send it back for an embezzlement trial, I guess, if the court wants to do that, but as far as larceny over $1,200, that cannot stand based on the facts that came out during this bench trial. It doesn't stand. Can't. I will be prepared to argue the evidence insufficient as it relates to the identification of Ms. BRETAL. So, as we know...
Before you get there, just the embezzlement larceny thing that Mahoney stands for, that's not argued in your brief, right?
I didn't draft the brief, Judge. I'm a stand-in. Somebody else did.
That's not argued in the brief that we have.
It was not argued in the brief that was filed by prior counsel. CPCS asked me to step in and pick this one up, and I did that. That's why I filed the 16L letter to reference the court to the Commonwealth versus
Just want to clarify.
You're raising it for the first time.
Raising it in the appellate proceeding as per Rule 16L. So it's not in the brief. Like I said, I didn't. Had I drafted it, I would have certainly made the argument accordingly. So the question now becomes identification. Is or was Ms. BRETAL the person who took the money? The patient comes in, gives $1,500, as we know, all $100 bills, and at the time he comes in, there are two young girls behind the desk wearing scrubs, masks, darkish hair, and if we assume the facts in the light most favorable to the government, two girls are there, BRETAL is there, somebody else is there, and there's no dispute he turns over the money. After that, the dentist testifies that BRETAL was working the front desk. A girl, she had red hair, dark hair. Again, nobody describes any facial features, nothing of any specific characteristics. At the time, maybe two people behind the desk. And then she says, the dentist says, she never saw CUNA give any money, and she insisted there was money in an envelope in a drawer next to Ms. BRETAL. Lastly, the owner really doesn't offer anything except no video surveillance. There were some questions about the cash payments, but I'll get into.
Well, Mr. Khanna testifies that the defendant was the sole person at the front desk who would have collected money.
Yeah, that's not how the evidence came in. He said that, but he wasn't there to establish that because he wasn't there on the day the money was submitted. So on the day the money's submitted, we have the dentist and we have the person who made the payments. Two people are behind the desk. There doesn't seem to be any dispute behind that. The question now becomes, who takes the money?
So Dr. McCool, she says first in her affidavit that does not come into evidence that she saw the cash in the defendant's hand. But she has no memory of that at trial. But she does say that her memory was better at the time she drafted the affidavit than when she had a trial.
Sure. And if that,
so could the fact finder credit that testimony that she had the cash in hand?
The fact finder could credit it, but it would make sense because if CUNA came in and gave her the money, then she would have seen the money. But she didn't see CUNA make any payment. She didn't see Mr.
Well, I mean, he comes in with $1,500 bills and presumably gives them to the defendant. And then she sees her with the money. Dr. McCool sees the defendant with the money. Well, I mean, that's not a huge leap.
I'm not going to go that far, Judge, because it was very specific about an envelope and $1,500, $100 bills. She doesn't identify the denominations. She doesn't identify how much money is in her hand at that particular point.
But she identifies it as cash. And if she just saw an envelope, how would she know it didn't have a check in it? She says cash in the defendant's hands.
But how does she know it didn't come from somebody else after Mr.
Well, the Commonwealth isn't obliged to exclude hypotheses of innocence.
Sure. The problem here, as I see it, is let's assume the money is turned over and it's given to Ms. BRETAL. What isn't explained is what happens after the money is in lawful possession of Ms. BRETAL or the other girl. What happens after?
Well, it's not logged in. It doesn't go on whatever ledger they have. And then there's a series of lies that the defendant has in conversations with Khanna, I think. She lies about some sloppy payment arrangement. She lies that she knows CUNA. She lies that CUNA has COVID, and that's why. I mean, these are all very strong evidence of the consciousness of her guilt.
Well, consciousness of guilt doesn't establish identification, Judge, and frankly...
No, but it does provide a link in the chain of evidence.
Well,
that the inferences only have to be reasonable and possible, not necessary or
I don't think it's reasonable in light of, I mean, the court maybe overlooked it, but what about the email showing the payment CUNA made the $500 payment against the $1,500. That email also came into evidence reflecting a payment against an outstanding balance. So the trial judge ignored that. And we just want to focus on sloppy payment plans, has COVID, and will pay over time.
Yeah, but he's entitled to look at the evidence in the light most favorable to the Commonwealth,
But
not most favorable to the defendant.
That is evidence. My issue...
You can discount emails that contradict the Commonwealth's theory.
My issue with this is we don't know who converts the money after CUNA makes the payment. This is what we have on the 27th.
Dr. Khanna, I'm not sure if he's a doctor, but Mr. Khanna says the defendant was responsible for taking the money to the bank, and it never showed up in the bank account, according to Dr. McCool.
That's understood, but I'm talking about the day of, Okay. So I'm going to refer the court to the some oldies but goodies, Salemi and Maza cases. Those two murder cases, Salemi was classic. 10 minutes before the shooting, they go into a restaurant, they're sitting in a restaurant, and someone gets shot. Who pulled the trigger? I don't have in the record here anything that explains what happens to that money after CUNA makes the payment with the defendant and another girl at that front desk. The stuff that comes in after, consciousness of guilt, the sloppy payment plan, he has COVID, sure, but that doesn't identify the person who actually...
Yeah, but in the chestnuts, as you referred to, the evidence supposedly in equipoise did not have anything more compelling from one versus the other. Whereas here, there's no other person that has as many ticks on the chain of guilt going against the defendant, including that she'd been looking for a loan first from McCool and then from Khanna to pay her car insurance.
$1,500. I mean, at best it gets you to motive, but it doesn't establish identification.
No. It's just one of, and then the lies, and then the circumstances, and then the money in her hands, her responsibility for depositing the money not being deposited, and then more lies to Khanna about why CUNA hasn't paid yet.
I still don't have any evidence in the record that BRETAL was the one who actually took the money. And when confronted with that, she said she didn't. So CUNA goes in and pays the money. CUNA gives somebody the money. Then after he leaves, we don't know what happens to the money. Yes, it never makes it to the bank account. Yes, she comes up with some stupid lines about he's going to make her pay and sloppy payment plan. But there were two girls at that point in time. The money was received. What happens at that point? So there's an inference. Two people had...
Wasn't the other young lady that was there was a dental assistant? She wasn't an office manager like the defendant, right?
I don't know, but she had equal access.
Well, I mean, I think the record...
Oh, the record reflects that she is what she is, but I don't know...
But she's not an office manager.
Understood.
Her job is not to collect money.
But there was no evidence that she didn't have access to the money. She worked behind the desk along with Ms. BRETAL. So what's missing is what happens after that payment is made.
Dr. McCool says she saw the cash in the drawer right next to the defendant after CUNA left.
The issue with that is the envelope. I specifically said the cash was in an envelope. CUNA comes in and says, I never gave anybody any money in an envelope. So I don't know whose cash that is, where that cash came from. The bills aren't identified, not even the amount. So it could have been $700. It could have been somebody else making that payment.
Was there any evidence of when the defendant talked to Mr. or Dr. Khanna about the wanting the loan to pay off her auto insurance?
I believe there was some correspondence going back and forth.
Well, there were texts, but I didn't see a date on them.
I don't recall.
Is there evidence that occurred before or after the date that Mr. CUNA gave the money?
My understanding of the evidence is Dr. Mahul testified that it came up perhaps the day of or shortly thereafter. I didn't have a specific date when that issue came up. It did come up at some point in time. I think it's a weak motive. $1,500 isn't going to get you to $4,500 to satisfy a car insurance payment.
I have sort of a housekeeping question,
Sure.
which is that the docket says that this case was resolved by a guilty plea. If we were to affirm, should that be corrected?
I believe it should, Judge. I did not handle the preliminaries. I did see that. I was a little perplexed, but it looked like it went to a verdict, a bench trial.
She rejected the guilty plea, the first one.
She did.
Yeah.
And then it went to a different judge, right? After that, the judge rejected the guilty plea, and then it went to a different judge.
I believe the docket reflects some other judge who was going to take a guilty plea.
Sorrenti
She
was the
threw
trial
that out
judge,
and then went to
Judge Coyne rejected the plea.
Judge, again, I'd ask on Mahoney, I don't think it stands, and I don't think there's enough identification to find her guilty. I'd ask the judge, the court, reverse the conviction. Thank you.
Thank you. Ms. Gauthier.
Good morning, Your Honors. May it please the Court, Stacey Gauthier for the Commonwealth. Excuse me. I'd like to just start to address, with addressing the defendant's 16L letter. I would suggest that the defendant's argument about embezzlement and larceny is waived. My understanding of a 16L letter is the purpose is to just provide additional case law to arguments that have already been made in the brief. It's not to make a new argument. So I would suggest that that argument is waived since it wasn't addressed in his brief. My brother could have filed a motion to file a supplemental brief. I've had that happen before where there's different attorneys. And also, I mean, looking at the statute, Section 30 states, whoever steals or with the intent to defraud obtains by false pretense, or whoever unlawfully and with the intent to steal or embezzle converts or secrets with intent to convert property of another. So I would suggest that the larceny statute that she was charged under covers both embezzlement and stealing and by false pretenses. And then with regard to the sufficiency, it's the Commonwealth's position that there was sufficient evidence presented that she stole or committed a larceny over $1,200. When we look at and consider the issue of the sufficiency of the evidence, we look at the evidence viewed in the light most favorable to the Commonwealth and whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. So here, looking at the defendant, she's in the position to take the money. She's the front desk / office manager, and it's her job to sit at the desk and take the payments. She had dark hair at times, sometimes red, but at times she had dark hair. She wore scrubs, quote, quite often, according to the owner. He said he mostly saw her in scrubs. So that, that fits the description. And then in addition to that, we have the dentist who had testified that on April 12th of 2021, she had written an affidavit, and although she didn't remember this at the time of trial, she testified that her memory was better after the incident occurred, but she stated in her affidavit that she saw cash in the defendant's hand that she kept in a drawer after Mr. Kuna left the office. Although she couldn't remember that at trial, what she could remember at trial was that she remembered seeing cash in an envelope in an open drawer of the filing cabinet that was next to the front desk, and the defendant was sitting at that desk that day. And it's the defendant's job to take the money. And then
what day was it? I was confused whether it was the day of that he says that he gave the cash or the day that he gave the check, which is the second time we actually.
I thought that she was talking about at the time of the payment. Because, I thought she was talking about at the time of the payment. That's why the prosecutor was asking her that. And then, although there was other people who had access to the front desk, what I would suggest were like what I'm calling plus factors that I would suggest tip the scale in favor of sufficiency. We have that she had repeatedly lied about payment plans. She had said that he was, Mr. Kuna was on a sloppy payment plan. The owner testified he never heard of a sloppy payment plan. And then he was on some other payment plan. He was going to bring in $500 one week and then $1,000 the next week. But all the evidence from both the owner and the dentist were that the payment plan of the dental office was half before the procedure and then half at the time of the procedure. And that was confirmed by Mr. Kuna, who testified that's what he was told when he went in to make the appointment for the dentures. That's what he was told, and that's why he left and went and got the cash. We also have her, telling the owner that she's communicating with Mr. Kuna and telling him to come in and make his payments, and he's, according to him, she's not communicating with him. the first time that he heard that there was money missing or a problem with the money was in approximately February when the owner called him. On top of that,
Do
yes.
you see any evidence about when the conversation with the owner about the loan for the auto insurance was?
Yes, on the record appendix, page 16, that's on the text message. It was her text message to the owner. Right under her name, it says in small print, it was on Monday, November 16th at approximately it was like 3:40 p.m. That's the day before Kuna came in with the cash.
Right. So, but that's a communication between Dr. McCool and the owner, not a communication between the defendant.
That's correct. And my memory is that the dentist testified that she told Mr. Kuna, it was shortly after, like within a day or two after she spoke to Ms. BRETAL about it. I could certainly try to find the...
Can we just get back to the embezzlement theory for a minute?
Yes.
Let's assume that the issue's in the case and that we determine that that larceny wasn't proven because she had it lawfully in her possession. I thought I heard defense counsel say that this could be sent back for a trial on embezzlement. Do you agree with that?
Well, I don't agree with it because I agree that the three charges are all merged into one. And my understanding is the reason that was done was that so the Commonwealth doesn't put forward a case on, larceny by false pretenses and then prove embezzlement, and then the person gets a walk because we didn't prove embezzlement. So I don't think that. I think that they're all the same, and I don't think that there's any reason to send it back.
But the embezzlement theory wasn't presented to the judge.
I'm sorry, Your Honor?
The embezzlement theory wasn't presented to the fact finder.
Well, it's the same facts and it's the same statute. So I think whatever was proven, I think it would fit within the larceny statute because larceny covers all three of them. And I think the issue's waived too because it wasn't addressed in the brief. And if there's no further questions for anything that wasn't argued, I will rest on my brief.
Seeing none, thank you. Thank you,
Thank
Paul.
you.
Do you want to do one more?
Sure.
Do another one? The next case is 2522, Department of Children and Families versus Mother. As you all know, this case is impounded, so please use pseudonyms or other references other than people's names.
Someone important is missing.
Yeah. Oh.
Maybe that's her. Yes.
Thank you, AJ. Ms. Chenevert.
Yes. Good morning, Justices Meade and Sachs and Massing. May it please the Court, my name is Dana Chenevert, and I represent the mother. The crux of Mother's argument in this case is that there is no nexus between DCF's alleged deficiencies in Mother's parenting vis-a-vis her mental health, the manifestations of her behavioral health, and her alleged substance use during the course of this case. The record reflects that even before DCF removed the children in 2020, the children were in great shape. They were visible in the community. They were attending daycare regularly. They were always, from the accounts of the daycare personnel, their doctors, they were always clean and well-dressed. They were medically current, and they were happy and bonded with their mother. Now, it's undisputed that the children were both born substance exposed, but they were exposed to Mother's prescribed substances. The medical
Was it
marijuana.
prescribed?
She had a medical marijuana card, which she was using. Didn't see that.
The judge said it wasn't a prescription, though, right?
She had a medical marijuana certification.
No, I understand that, but it's not a prescription, and I think the judge made a finding to that effect that you don't challenge.
Sure, I guess technically, right, not prescribed, but
We're all about technicality.
sure. But she had a doctor who had certified her requirement or necessity for the medical marijuana, and mother presented a letter to DCF to that effect from this doctor. So, correct, marijuana is not prescribed, but she was permitted to use that to eliminate or alleviate the symptoms.
And she had been told not to smoke marijuana as a caregiver, right?
While she was caring for the children, and I believe that the record does not reflect that she did that. She was using the medical marijuana to eliminate or minimize or address the symptoms from her diagnoses.
But she was told not to smoke marijuana when she was pregnant, right?
She was asked not to use marijuana.
But she did.
But she did.
Okay.
However, the action of doing that did not impair her when the children were born. You know, there was no harm done to the children. There was no, like I said, connection or nexus between her use of medical marijuana to eliminate her symptoms due to pregnancy or mental health issues and her care of the children. Same with the methadone. The methadone was prescribed to her in the course of her treatment, her dual diagnosis treatment. That again, the mere presence of the methadone and THC in the meconium of these children did not impact her ability to care for them. Same for her mental health issues. She did have some breaks there in mental health. However, the morning that the children were removed, she had dropped the children, she had deposited them safely at daycare. The daycare workers noted when they were interviewed during the 51B investigation that they didn't see anything, abnormal about mother's presentation. She was
civilly committed for mental health issues.
That is what DCF alleged, but she was not sectioned on that date. A section,
I thought she told the department that they were tapping her. The department was tapping her phone, and she was fighting monsters and goblins, and that everyone was against her, and there was some military conspiracy that she had in mind too.
She had some thoughts that were, yes, she was paranoid. She presented some symptoms of paranoia. But even her in-home care provider said that, yes, that weekend that she received 35 text messages Friday to Sunday from mother, said that, yes, she indicated that there was that mother was paranoid. I think she did use that term, but that it did not seem to impact her parenting of the children.
And she thought she had some sort of relationship with the social worker and sent her inappropriate texts.
That is correct on the record, Justice Meade. However, again, we're going back to the premise that this did not impact her parenting of these children.
I mean, all of these things, the drug dependence, the domestic violence, the mental health issues, and her care of none of this you think is in any way connected with her being a proper caretaker, or that having the mother be the caretaker is in the best interest of the child?
I would posit, Justice Meade, that there.
I'm sorry, what?
I said I would posit. I would argue on mother's behalf that you can have mental health issues. You can have an irrational, or what might be deemed to be an irrational crush on your social worker. You can behave in ways that might be construed as being strange to some people. But if you can care for your children, which is what mother.
Excuse me. Can you turn that phone off? Go ahead.
If you can provide at least the minimally acceptable level of care for your children, which mother did more than that. The children were always clean, always fed, happy, in the community. She is dropping them off at daycare on a regular basis. They are missing no daycare at all. And not only is she doing this, she's doing this in a way where she's put together. Nobody
that she interacted with, the children's doctors, the daycare personnel, ever had any concerns for mother's care of these children or the children themselves. The day the children were removed in that September 2020, yes, she was held at the hospital, but she was not sectioned. And in Mother's brief, we asked this court to take judicial notice of the fact that a section requires a 72-hour hold. Mother was discharged within 24 hours of being held at the hospital, and she was held at the hospital. The children ended up being removed because she wasn't going to be able to pick up the children by the time it was time to pick them up. Now, the question becomes then at that point, removal is supposed to be the last resort. Why didn't DCF call the emergency contact to pick the children up when they knew mother was at the hospital? Instead, they immediately took these children into custody. And here mother is over 3.5 years later, because that was September 2020 and this is December 2023, fighting to get her children back. They could have easily asked the maternal grandmother or maternal grandparents, who were now the guardians for the children, to pick the children up from daycare until mother got out of the hospital that afternoon. And, arguably we would not be here. But that is not the course of action they took. So now that mother was then under the careful, even being more scrutinized by DCF, and they're saying, yes, she has a history of mental health. Well, yes, she does. That is true. She has a history of substance use. Yes, that is true. Those things, however, did not impact her ability to care for these children. And from a policy perspective, there are people every day battling these things within them, but their children are taken care of. You don't take children away just because somebody has a mental health issue. There has to be a connection, and that is what is missing from the judge's findings. The judge seems to focus on the fact that these issues exist. There are no findings as to the connection of these issues to mother's parenting. There's no findings about the children's condition while they were in mother's custody prior to the removal. The findings do focus on the children's condition after the children were removed, but it doesn't say anything. There's no evidence in favor of mother, which that the judge concluded in her findings that would disfavor the judge's conclusion about termination here. And so that is what's problematic about this case, I would argue, on mother's behalf.
Can I ask, you have an argument that the maternal grandparents' willingness to become guardians sort of obviated the need to terminate parental rights. I don't quite follow that. Could you explain that?
Termination of parental rights is supposed to be a last resort, where the maternal grandmother was willing to be the children's guardian she was a children's guardian prior to or during the pendency of the case. That's an option here, especially where mother argues there's no real nexus, like the substance use, but even more so the behavioral health issues. We have to concede might in the future possibly be an impediment to that continued sort of being present for the children, but termination is not necessary to achieve permanency for these children because they have the maternal grandparents as an option and the mother has a connection with them. So
would mother need to consent if they didn't terminate her rights?
Would she need to consent to the guardianship?
Would she need to consent to the guardianship? Yeah.
Would she or would she need to?
Would she need to?
She would not need to consent to it.
Was the guardianship request, was that raised below?
No, it was not raised below, so I understand that this court might deem that issue might be waived. However, termination, the case law is clear that termination of parental rights is an extreme step, and that the judge could have, without a proactive motion, without a motion from the parties, could have considered guardianship as an option, and the judge did not. The sibling visitation issue was one last issue that mother had an issue, that mother brought to the attention of this court. There's a statute, General Laws 190B, 26BB, that requires the lower court to ensure that children who are in foster care have access to and visitation with each other when, in the course of state intervention actions. That order was not entered here, and if this court
Aren't they
allows...
living together?
I'm sorry?
Do they need aren't they living together?
They were living together, but the permanency plan proposes that the boy be reunited with his father in
So at the moment there's no need for an order of sibling visitation because they're together.
But if this court were to allow that permanency plan to stand, this child might be sent abroad to Brazil with his father,
Well,
which
it's the statute lets you, 26B lets you, that be reevaluated.
I'm sorry.
You can seek visitation later, right?
That is true. But children can seek visitation if they would like.
And as I think Justice Massing was saying, the father too is in Brazil right now, and the children are together, right?
The father is in Brazil and the children are here, stateside, yes. However, if the boy is sent to Brazil, there's evidence of acrimony on the record between the parents, between the father and the current guardians, and the father doesn't speak English, quite frankly. Having to go through the red tape of, having this child assert his rights, this little boy assert his rights to visitation with his sister, unlikely, I would argue. So it's to ensure that these children, if this permanency plan is allowed to stand, to ensure that these children have access to each other going forward in the future, and for the sake of efficiency, to be remanded at this point for an order on sibling visitation to ensure they can maintain their relationship.
Can you clarify what is the criminal problem that the father has that is the impediment to that needs to be cleared up before he would be given custody? Is it a domestic violence charge based on complaint by the mother?
It is. It's assault and battery that got him deported.
And then he was deported before trial?
He was deported before trial, couldn't attend trial. He had to attend, or couldn't attend in person. He needed to attend virtually. And as far as...
Deported not based on the pendency of the charge, but just based on being here unlawfully?
Deported based on...
Was he deported because he was here unlawfully, or did the pendency of the charge have something to do with him being deported?
Well, he was here unlawfully, but then he engaged in criminal behavior while he was here and came to the attention of the criminal justice system, and then got deported and can't come back because he still has, I would like this court to take judicial notice, he still has a warrant out, a bench warrant out for his arrest. But he's deported because of the criminal charges, is my understanding.
But then he has no way to come back
He
and clear them up because he's been deported?
He could come back. But he would have to present himself to the court, is my understanding. If there are no further questions from the panel, I would rest on my beat. But before I go, I just want the court to the nexus, the behaviors, they exist, unrefuted, but did they impact mother's ability to care for the children, and they did not. Thank you.
Thank you. Mr. Bayless.
May it please the Court, Jeremy Bayless from the Department of Children and Families. I think we should probably start with the nexus. Mother is engaged in several behaviors, manifestations of her mental illness that are pretty dramatic. But she's also engaged in manifestations that are less flashy, but demonstrate some concerning facts. Mother has been volatile for most of these children's lives. She engaged in a physical altercation with her brother that led to the family losing housing with the maternal grandparents. She was evicted from the housing that she shared with father because her relationship with the landlord deteriorated due to her harassment to the extent that the landlord required a police escort anytime they did any maintenance or activity inside the home. Mother exposed the children to domestic violence with father, although the record is not entirely clear whether the extent to which that happened, because mother also testified at trial that she told father's lawyer that she had made up the allegations of violence to get back at father. Mother made, in addition to the professions of love to the social worker, Mother sent threatening emails to the department's supervisor threatening what would happen if they did not take her allegations against the maternal grandparents seriously. Mother made unsubstantiated allegations of sexual abuse against the maternal grandfather, who is a current caretaker for these children, who is an important person in their lives. Mother alleged also that the department's social worker, who had no connection with this family at all prior to her work-related connection, had been abused by the maternal grandfather as a child as well. This is not a case where Mother simply behaving bizarrely and being penalized for it. Mother's behaving in a way that is deeply concerning, that she has been volatile, she has been violent, she has been unable to maintain safe, stable housing, and as of trial, she was living in a basement that she testified was not a safe place for the children to leave. There's ample evidence on this record of a nexus between Mother's substance abuse and mental health disorders and the fact that it has impacted the children. And then what the actual question is that the judge has to assess whether or not, were the children returned to her care, would they be affected? It's unquestionable that Mother's mental health got worse after removal. The judge has to assess whether or not that mental decline is going to have an impact on the children, and they did so. And that question and that determination is entitled to deference because it is fully supported by the evidence.
Can I ask a question? The action plan, one of the things in the action plan is for Mother to maintain a sober lifestyle.
Yes.
In this case, does the department consider the use of marijuana consistent with or inconsistent with a sober lifestyle? In this case, I would consider it inconsistent. While marijuana is legal in Massachusetts, it should be, I think they would be comparable to alcohol. Your average person, use alcohol, fine. Don't be incapacitated. Don't be under the influence while you're taking care of a child. Don't use it while you're pregnant so your child is born with birth defects attributed to it, as the boy here was with marijuana. But this is a case where Mother has had a lifelong struggle with substance misuse. She's been abusing a variety of substances. She's claimed to have ceased use of all substances and then promptly tested positive for abused amphetamines, Adderall, and for marijuana. She relapsed a year before trial on what she claims was alcohol, but the judge found was more likely a narcotic because she was found on ice with an empty Narcan dispenser next to her. And she had ceased a participation in her substance abuse services for a substantial period of time by the time of trial. So there is this is apparent where casual use of marijuana is not in keeping with what she needs to be doing to create a safe environment because she's demonstrated that it does link to. And that's even with the doctor saying that she needs it for therapeutic purposes?
Well, I'm not exactly an expert in that medical provision, but if it was necessary for medical purposes, then she would have a prescription. A recommendation, a letter from a doctor, I don't really know what weight to give to that. And the judge is the finder of fact, who's the one who's to assign the weight, and the judge gave it very little. She claimed to have a medical marijuana card, couldn't produce it. She claimed to have a prescription, couldn't produce it. What she produced was a letter saying that she should use it. But especially given also Mother's use of marijuana in lieu of mental health therapy or of medication for that, it's concerning, and the judge was properly concerned and did not err in finding that that presented a risk.
Yeah, thank you.
Thank you.
Mr. Heffernan.
Good morning, Your Honor. May it please the Court, Peter Heffernan on behalf of the two minor children, the older child, child 1, and the younger child, child 2. Your Honor, I'm asking the Court to affirm the orders of the trial judge, finding Mother unfit as to both children and terminating Mother's parental rights in furtherance of the adoption plan for child 1. Following up on, as Mother's principal argument here.
It's just such a small window of time. Can I just ask you to comment on visitation order? Do you think it's necessary? If the plan of the father is carried out, would you seek visitation at that point?
You're right. At this time, no, a visitation order would not be necessary. And I do want to point out that with respect to child 2, the only orders before this Court at the trial level. The only orders on appeal are three. One is a finding of unfitness as to mother. The other is a finding of unavailability as to father 2, and the court's order committing child 2 to the permanent custody of the department. The court issues no order with respect to long-term planning or permanency plan for child 2. Those issues remain in the trial court. Neither parent's rights were terminated. They both have standing with respect to child 2 to litigate review and redetermination, sibling visitation, to raise objections to DCF's decision-making with respect to placement, et cetera. So, no, Your Honor, sibling visitation is not required at this time. With respect to nexus, Your Honors, I just would, in the children's brief, pages 36 and 37, I list a number of specific findings of fact that draw a nexus between mother's behaviors and her parenting capacity. I think to review, there was, of course, the incident on the 20th of September in 2020 when mother was, due to her deteriorating mental health, paranoia, and delusional thinking, was held involuntarily and therefore unable to care for the children. Finding of fact 109, mother behaved inappropriately and fought with her parents, often in the presence of the children. Also in that finding, mother did not appear to understand the impact of her conflict with the maternal grandparents on the children. Also, with respect to visits between mother and the children after removal, they were just, the court found in finding of fact 155 that visits between mother and the children were chaotic. Mother required multiple instances of redirection due to inappropriate conversation, and mother presented as disorganized and unable to effectively manage her time with the children. And there are more. Lastly, I would just say finding of fact 122 is mother's failure to acknowledge how her mental health impacted the children. And I think this is a critical part of this case. That mother, there's no evidence in the record that mother made progress addressing any of the issues, any of her substantial issues, and those issues render her unfit as to both children. With respect to the court's determination of approving the department's plan as to child 1 and terminating mother's rights, the court committed no abuse of discretion in making those determinations. The trial judge had sufficient information with respect to what that plan was, and it was a fully developed plan. Child 1 had been, at the time of trial, living with the maternal grandparents for 2 years, bonded to that family. The adoption plan, the family had been approved as an adoptive resource. There was no abuse of discretion in the court's approval of child 1's plan, and obviously the furtherance of that plan required termination of mother's rights. If the court has any questions?
Seeing none, thank you.
And I would just ask that the court affirm the lower court determination with respect to mother's fitness and best interest of the child. Thank you.
Ms. Butler.
Deborah Sirotkin Butler on behalf of the father of child 2. First, I should point out to the court that father testified in English through the medium of Zoom during the trial, that he ran a drywall business on which he paid taxes in Lowell for 15 years in English. So I respectfully state that father does speak English and speaks it well. We went into detail in our brief as to why he was deported. He first entered the United States illegally when he was barely 18. His father had come first and asked him to join him, and he was deported. He returned, set up a business in a thriving Brazilian community in Lowell. and was well known in the community. He has 2 older children by a prior partner, which he was supporting with their mother, with whom he has a good relationship. He did become involved with mother and attempted to assist her to sobriety and believed he could help her save herself. We go into considerable detail in that, and those facts are between pages 9 and 13 in our brief. In terms of the argument that...
Wait, just to finish that up. So then he's arrested on the domestic A and B, and that brings him attention of ICE, and he's deported for the illegal entry?
That's right. And it's his understanding, and there is some evidence to it, that mother may have brought him to the attention of the authorities. We don't know. It was during a period under a prior administration when there was very active deportation also. He was grabbed off the street after the arrest for the alleged domestic, which there is not a preponderance of evidence for. The trial judge, and I think she did a good job with it, did not find that to be credible. The first attorney representing father withdrew because mother's comments to her rendered her a witness, and she testified at the trial, and her testimony is in the transcript. Father was appointed new criminal counsel who attempted to have a trial held because father very much wanted to clear his name, but that district court judge would not allow him to be present by Zoom. He would have testified.
He was in
at
Brazil.
The time of trial.
He was in Brazil at that time?
That's right. He is living in his family home, which the family built itself 50 years ago, living with his mother and his uncle, as is shown in the home study done in Brazil. At the time of trial, he had secured immigration counsel, and there was a pending immigration case, which had not yet been decided at the time of trial, and he instructed counsel, I'm in the unusual role, I was also trial counsel, that he was going to continue to seek legal reentry rather than fight for immediate custody because he wanted to be near all 3 of his children and resume his business. It should be pointed out that not only did he pay his taxes and have a positive home study, but the social work testified that he was in full compliance with his action plan. He made the effort to participate in the Nurturing Fathers program virtually through Zoom, to utilize services in Brazil, to meet with the guardianship council in his town, and to fully cooperate with a full international home study, who came to his home, who met with his mother and his uncle, and that is part of the evidence presented to this court. So we would submit that there isn't a preponderance of evidence that domestic violence occurred. There is no other record of assaultive behavior by this man. On the other hand, as to mother, there are multiple instances of assaultive behavior.
We're going to have to leave it there, Ms. Butler. Your time is up.
Thank you. Unless there's further questions.
No. Thank you. Seeing none. Thank you.
Thank you.
Thank all of you. We're going to take a short recess, and then we'll reconvene.